Good afternoon, everybody. We're going to let the people in the lobby get filled in here. We got a lot of people signed up for this, so we'll give it a minute or so for our crowd. All right, well, as people continue to file in, we can go ahead and start kicking this off. So good afternoon, everybody. My name is Isaac Schloss. I'm the Chief Product Officer at Contact Center Compliance. For those of you who are not familiar with us, Contact Center Compliance partners with their customers in complying with many of the regulations regarding customer or member outreach. This includes scrubbing the records against state and federal do not call lists, looking for number reassignment, weeding out known professional plaintiffs through our litigator scrub, and a lot of other list hygiene services. We can then go a step further by helping with final call delivery through our remediation and call branding services. We don't just monitor your caller ID reputation, but we can automatically work to pull customers off the list that show them as a potential spammer, or even implement a text display on the caller IDs when they call their consumers. Now, as a quick piece of housekeeping, I'm sorry, the holiday weekend has me tongue-tied still. We do have a Q&A tab. You'll see that right at the bottom. Viewers can post questions or comments there. We'll do our best to address all the questions during this call, but if we run out of time, which we often do, I will follow up with anybody over the next couple of days that has registered with a valid email address. So if you're one of those people signed in as anonymous, or you post a question anonymously, if we don't get to you, I won't have any ability to get back to you, so sorry about that. Also, we get asked this question a lot. We will be posting this video to our website, dnc.com. It should be there in the next couple of days. Now, compliance isn't a one-time thing. So while we would like to keep the conversation going, there's always going to be a need to speak with some sort of expert, whether that's our expert speaker that we have today or somebody in our team. We will put a link in the chat for talking to one of our experts here, and you'll definitely have the information you need to contact our speaker at the end of this call should you need it. And on that note, while our guest speaker today is an attorney, every business is very different, and the information shared here should not be taken as legal advice. We recommend that any changes to policy be reviewed with your compliance team and qualified counsel that specializes in this type of law. And if you don't have an attorney who does that, I do have some recommendations. A completely unrelated note, I'd like to welcome our guest today. He's no stranger to these webinars. It's Eric Troutman. He's known as the Czar of TCPA world, and he's one of the country's prominent class action defense attorneys. He's nationally recognized for his knowledge and expertise in the TCPA, and he litigates national cases all over the place. I know when I first put a speaker bio together for him, it was 300. I'm sure that number has been knocked out of the park since then. On top of that, he frequently advocates before the FCC for just sanity in the TCPA. He helps the industry through countless speaking sessions, webinars, in person. I could go on, and even right now, he's talking to you guys from a hotel in somewhere in the country right now, because he doesn't just spend all of his time speaking, he also spends quite a bit of time helping people out. So, Eric, thank you for joining us today.
Thanks, Isaac. Yeah, so always happy to be with you folks today. I literally am in like a hotel lobby in Des Moines because I'm driving, don't ask me why, from Kansas City to Chicago. And this fell just like smack dab in the middle of the drive. So we just stopped. I'm traveling with Pujo. We just stopped literally in a lobby of a hotel and we're hanging out. I put my sticker up here on their pillar. Hopefully they don't mind. But there's so much to talk about. And I'm really excited to have so many folks here right after Labor Day weekend. This is really great. Looking forward to it.
Yeah, well, thank you. Well, and if you guys like seeing the Troutman logo up places, I highly recommend you go through John Wayne Airport. You will see it once or twice at least as you pass through that airport on the various advertisements there. It was really cool when we had the Law Conference of Champions just a month and a half ago now. Seeing that all over the airport was really exciting and really kind of created that initial experience walking off the plane. So Yeah, that was really great. Well, there's a lot going on, and you guys are at the center of it, and I can't stress this enough. If you guys do not follow TCPA World, you need to do that. There's no cost. Go to the website, you sign up. We'll get you a link to that shortly. Don't worry about that. But there are breaking stories all the time. Sometimes 5 or 6 in a day. I read every single one. They're not typically long reads, maybe 3 to 5 minutes. A lot of different people over at Troutman and Mean bring those stories to the front, so you get different types of material, different perspectives. It's really good reads, and really what we want to start with is talking about some of the things that have been happening in the TCPA world, specifically around lawsuits. If any of you on this call happen to catch Pooja's webinar last week that she did, she had mentioned a 40% increase in lawsuits around the TCPA, 40%. Yet Eric covered in July that we were at 200 million with an M, 200 million fewer robocalls in July of 24 than July of 23. So robocalls are going way down, assumedly illegal ones are going way down with that. But then the lawsuits are going up. So clearly there's more that businesses need to consider, need to look at. So today we wanted to go through some of these things that have been happening and give you guys advice or tips, I should say, on how to avoid some of these pitfalls. And one of the big stories that we're going to start with right now involves Quote Wizard and a $450 million settlement they're potentially looking at. So as we go through these, we're going to put some links in the chat for you folks. So that if you want to check these stories out, go ahead. And while you're there, if you're not already following TCPA World, it'll be very easy for you to start doing that. So, Eric, why don't you tell us a little bit about what's going on with Quote Wizard?
Yeah. So, look, everyone's focused right now, as you should be, on the FCC one-to-one ruling, which we're going to touch on here, right? That becomes implemented in January of 2025. Everyone is correctly concerned that when that ruling becomes effective, that TCPA class actions are going to continue to spike. And that's true and that's right. We need to stay focused on that. However, we have to recognize that, the guys that are doing it the old way, right? The non-reach members, non-members of responsible enterprises against consumer harassment, right? The new kind of holistic, looking forward, positive future of this industry. The folks that are stuck kind of in the sand doing it the wrong way are getting picked off one by one and getting slaughtered, just killed. And Quote Wizard, unfortunately, found that out the hardest way. Just a couple of weeks ago, there was a class action certification order that was entered. And we don't know what the full judgment is going to be in that case. We do know they're looking at outside exposure of about $450 million. It could be as little as $150 million, maybe less, depending on how the class certification process and the new trial process moves forward. But that case was certified. And those of you that don't know the background facts here, remember, this is a purchase lead situation where Quote Wizard ingested the lead, made outbound calls, right, based upon the purchase lead, moved for summary judgment, tried to enforce the lead, Isaac. And this is just so emblematic of the problems with the lead generation industry. This lead actually came from a pirated website. I think it was Belarusian or something, some offshore website. Allegedly, it was being pirated by somebody else. Wasn't even the actual alleged owner of the website who was selling this lead into the affiliate market. Quote Wizard ended up with it, still tried to move for summary judgment, enforcing the lead. That the IP address didn't match the consumer. They actually took the deposition of the owner of the IP address, and the guy was like, dude, I had nothing to do with this. I did not fill out this form. This is fraud, right? Obviously, the plaintiff said this was fraud. Even Jernaya said this was a fraudulent certificate. Yet Quote Wizard still went to the court and moved for summary judgment. And of course they lost. And not only did they lose, when they were going through this process, they unearthed all these horrible facts and really empowered the plaintiffs to go to court and say, look, this is the problem with the lead generation industry. And the court absorbing all the facts and looking at all the circumstances and finding, of course, that the key fact, which is that Quote Wizard's name was not on the form, right? Set aside everything else. Quote Wizard's name is not on the form on these leads that were being purchased. The court had very little trouble saying this is a certified class action. These calls, maybe they weren't illegal. We're going to find out, but they were probably illegal, right? But no matter what, the common issues, right? There's commonality. All the same leads came from the same circumstances, and Quote Wizard wasn't on the name, wasn't on any of these forms. And that was sufficient for the court to say, I'm certifying this. Now, again, certification does not necessarily mean that the case is over, that they're going to lose. That doesn't necessarily mean that. But on the facts and circumstances of this case, as I just kind of explained, they are in a world of hurt, just a world of hurt. So we'll see kind of where this case goes. You know, many times post-certification, you see a big settlement, like an 8-figure settlement, which is what I'm kind of thinking may happen here. Don't know that, don't have any inside information on that, but it's sometimes what you see in these circumstances. Otherwise, this case is going to try, and the exposure here is just absolutely massive and crippling. And it really, again, it just goes to show, 1, make sure your name is on forms. 2, think about what kind of leads you're buying. And kind of 3, most importantly, if you've got a bad lead, don't go front and center to the court and try to enforce it, right? Courts are not dumb, guys. Like, they're not going to enforce a bad lead, right? You need to be very thoughtful in terms of how you're going to leverage that. And truthfully, you know, I hate to say it, but in a case like this is one where you got to be looking for an exit early and try to get rid of that case.
Yeah, you know, it's funny. I remember reading that story, and you know, this whole last, I don't know, I feel like it's been forever, probably about 1.5 years, 2 years now. We've all been talking about one-to-one, and you know, from when the NPRM came out to when the ruling came into place, you know, everybody's kind of thinking, what does it mean? What can we offer? And all this talk around, well, how many names can I have on my lead form and all of that? And I read the story, and I'm thinking, okay, so you don't have your own name on your lead form. That just seemed like a glaring error. So I know it's easy to speculate without having inside information, but it's the kind of thing where I look at it and say, did they have somebody review this that actually understood the rules for consent language? Because I mean, if this were something that were brought before, say, Troutman and Amin, I imagine that would be something you guys would have caught, right? That.
I mean, who's to say? No, I'm just kidding. Yeah, I mean, of course. I mean, like, that's one of the most basic things we're looking for. Now, these leads, though, as I understand this Quote Wizard case, these were not first-party owned and operated leads, right? They were buying and ingesting leads from third parties. And, you know, again, in the present state of affairs, right, this is before the one-to-one rule even, right? You still have the requirement that your name be on that form. It might be on a marketing partner list, right? Hopefully it's, you know, clear and conspicuous, that hyperlink that's being utilized. Regardless, though, your name still needs to be on the form. The regs require the seller's name to be on the form. You know, here Quote Wizards wasn't, so it's not looking good, right? I mean, it's not looking good.
Yeah, and you know, earlier you had mentioned some of the stuff that was being done at Reach and some of the best practices. There is something that you have posted, the Troutman Amin 15, which is the current kind of guideline, the generic framework that's been developed for businesses to follow for their lead forms. And I think this is a really good place for you guys to start. We're going to drop a link to that in the chat here in just a second. But you know, the Troutman Amin 15 is a very powerful tool for you to at least look at and get started. You know, attorneys, no offense, Eric, but attorneys can be very expensive. So if you're trying to get yourself in the best possible position before you go to an attorney to get advice, having looked at this, having tried to apply as much of this as possible before you get official blessing might be a good idea, and certainly worth a look.
Yeah, and let me say 2 things. 1, we are expensive. I'm going to be perfectly honest with you. We're about to become a lot more expensive. I'll just announce now, I'm going to be releasing here in 12 days our revised 2025 Troutman Amin rate structure, and our rates are going to be going up like 30-40%. And that's not because I don't love all of you. I do love all of you, but we are like really busy and we have to take care of our current clients. So for like the new clients that are coming in, starting 2025, those rates are going up quite a bit. So if you're going to retain us, guys, for like one-to-one advice, do it in 2024 before those new rates come up. That being said, you know, in furtherance of our commitment, like, we're not just here about the money. Like, we're here to really try to take care of people, clean up the industry, and help folks to comply, which is why we gave the Troutman Amin 15, which is our best shot at a fully compliant one-to-one disclosure. We just handed it out for free to everybody in the whole industry. Like, here you go, work off of this. Please use this, right? Again, get your own counsel. You can't just rely on a free template you found. But we tried really hard, and we explained all 15 points that you need to keep in mind when you're now converting from your current lead flow process to your new one-to-one process. And of course, not only is the Troutman Amin 15 out there as a great resource for you, but the new Reach version 2.0 standards, folks, are going to be voted on September 6th. That's this Friday, and will be out in public for everyone to read come Monday. Right, so you're going to have the Troutman Amin 15, and you're going to have the fully approved Reach version 2.0 standards They're going to give you all the nitty gritty detail, right? How big does this language have to be? How far can it be? What font colors? Like, how does it all work? We're going to give it all to you through the REACH standards. And of course, the REACH big network of buyers are going to be looking for only REACH certified, REACH sufficient leads here coming in January. So those of you that want access to that big buyer network, make sure that you are complying with that REACH standard.
I'm going to go back to the cost you mentioned earlier of your services, because that's a good segue into our next topic that I want to talk about. There are certain areas in life where I highly recommend, I'm not giving you advice, but I highly recommend going cheap. Like, for example, when I go buy ibuprofen, I don't buy the name brand. I get the Equate at Walmart, something like that. The Equate ibuprofen works just as well, in my opinion. When it comes to legal advice, if you're looking at something like this and something is significantly less expensive, there's probably a reason for that. And when you look at things like, hey, we're hoping the Quote Wizard gets out early and it's only an 8-figure settlement, think about the, let's call it $5,000 you may have saved in legal expenses. Does that make you more open to a 8-figure settlement? And, not going to speculate about that now. You guys can draw your own conclusions. But if you want to avoid being in one of the Troutman stories, I'd say that's a good idea. And that leads me to another great topic, because not only is there TCPA world where you could read about the stories, but I'd say about once a month or so, there's a episode of Deserve to Win dropped on YouTube that is usually filled with some sort of very compelling interview with somebody who's at the center of a TCPA case. And there's one in particular that I want to talk about, a company called PowerSol. Did we lose you, Eric? Looks like your video is frozen. One second. I think we're waiting. I think we lost Eric, so everybody just give us a second. I'm sure he'll be right back on. The wonders of hotel Wi-Fi. Hey, there you are.
Heck. All right. So it's my fault, buddy.
Oh, it's okay. It's all right. So we were actually going to jump into that webinar that you did, or the Deserve to Win podcast you did with Joseph Kenny, where he went up against none other than Avi Kaufman. And that's an interesting story. Yeah. Because we've got a situation here where we've got someone who, almost in a matter of principle, small business, I think he said something like 14 employees or something like that, but small business, revenue line isn't anything out of this world by any means, but doing well for his size. But the amount of money and expense he had to put in, he fought this case, and he won, but at what cost? So.
And this is the dark tragedy, right, of the TCPA and the litigators. And I don't know if there's anybody from the FCC watching. I know we'll put this on our YouTube channel. The FCC staffers many times will watch our YouTube channel. Guys, this is the problem with the TCPA, right? Just in black and white. Small, mid-sized companies, right, get just extorted by these sharks. And again, I'm not going to say in this particular case that Avi Kaufman did anything wrong, right? But we know what happens. And look, he ended up dismissing the case. If we're going to get to the punchline, so maybe he did. But I'm not going to say that definitively because I don't know. I don't have those facts. What we do know is that small businesses get extorted all the time by professional litigators, and sometimes not even professional litigators, just by professional plaintiffs' attorneys, right? Who know they're going to go in there, and it is way more expensive, right, to force these guys to litigate than it is just to settle. And like I told you before, with Quote Wizard, I'm going to tell you, when you have a bad case, you should settle. All right. And look, here I am, the czar of the TCPA, telling you that. I love to fight. Nobody likes to fight more than me. Believe me, nobody likes to fight more than I do. Maybe Pooja, but nobody else, right? Yet, right, when there's a bad case, we know, like, you got to just get yourself out of there, right? But what happens when you have a good case, right? You have a strong case. You didn't do anything wrong, which is what, Mr. Kenny told us. He didn't do anything wrong. He's got a small company. He's dialing manually. These are consented leads. Dude, we did nothing wrong. And now you've got a shark at your door demanding 60K, demanding 50K, right? What do you do? Now, in your heart of hearts, you think, oh, there's no way I'm going to pay this guy. There's no way I'm going to pay this guy, right? And that's what Kenny did. And I respect it. And PowerSol is a small company, and he fought hard, and he found himself a lawyer. It wasn't me. I'm telling a story about a different lawyer who did a great job, not me. And this guy doesn't even do TCPA work, but he was like, look, I'm gonna do it on a small budget because I don't like to see you get screwed over. And this guy fought and he fought and he fought. And eventually he gets this big bad Avi Kaufman, who everyone will tell you, like, this guy does not go away for a sneeze. He's a tough litigator, like, for sure. And he dismissed the case and walked away for nothing. Now, here's the other shoe dropping, though, is that Kenny, who's on our website, on our podcast, you guys should watch our podcast, Deserve to Win, right? Without, at intervals, 26th edition. Kenny comes in and he tells me that it still cost him like over 200K, right? And, in addition to all the wasted time, in addition to, the risk and the fear. And so you have to ask yourself, this is like the really tough stuff, right? You got the small business dumping over $200,000 to defend a case that he says was meritless, should never have been brought. It was complete extortion, according to him, right? Regardless, Avi he did walk away, so that does tell you something about the value of the case, right? And yet the guy ends up still coughing up 200K, and there's no remedy. It's not like he can go after Avi and get that 200K back, right? So it's really a place where the commission needs to understand, Congress needs to understand, folks need to understand, like, these lawsuits are abusive. They are really taking folks who are principled and just cracking them over the hot coals. And even folks that are just like, whatever, I'm going to write you a check, they're being extorted into writing a $40,000 check, which for a small business, like, that is it's a huge amount of money, right? At least it's not small sums. So it's all bad, it's all wrong. And of course, I hear about the story. I want to bring it to people's attention. Like, I want people to understand. On the one hand, I think Kenny's a hero, right, for fighting the fight, right? Because if he doesn't fight, if everybody fought like he fought, then this racket wouldn't work, right? Guys like Kaufman couldn't get away with this. Again, assuming that this is frivolous. The people that bring the frivolous cases for extortion, they couldn't do it anymore if everyone fought. Then again, you see the cost of fighting, right? And so it makes sense where most companies will be like, nah, I'm just going to write the smaller check. So either everyone needs to band together and it's like, we are going to fight, right? Just like this guy Kenny did, or everyone just has to understand they're going to get picked off forever until the regulators or Congress does something. Either way, it's my job to bring this story, and I'm glad that you highlighted it because I think it's a really big deal.
We've got a lot of business leaders that come to these calls, and it being one myself, you're one. Every decision you make as a business leader is an investment. When you're talking about spending your money, you're making an investment. Whether you're going to a show, whether you're hiring an employee, opening a new office, it's an investment. But you measure, what is my potential reward there, and what are my risks? What happens if this blows up in my face? Am I just out this investment, or is there bigger consequences? And I look at some of these TCPA litigators that are out there, whether you're talking to the attorneys or just the professional plaintiffs themselves that bring these cases. Oftentimes I've seen that they have a much lower investment in bringing the case than a significantly lower one than one has in defending. And I think that's why a lot of these end in settlement, because especially if you're getting some demand letter, you might be able to send them a few $100s, make it all go away. You don't have to spend thousands of dollars in legal fees. You get into the class actions, it becomes much worse. But those coming after you have a much lower cost. So they have a very low entry point into the market. This is a very, if you talk about TCPA lawsuits as a product, it's a very low entry point for businesses to get involved or people to start a business for it. Whereas when you're on the, let's say, defense side, I won't necessarily say victim side, because I'm not going to say every single one is frivolous, but when you're on the defense side, it becomes very, very expensive to do that. So going back to what we said earlier, make sure that you're in a good defendable position to begin with. Make sure things are getting reviewed. Invest that small amount of money compared to what it could turn into. But then beyond that, there are additional tools. We have one here at Contact Center Compliance at Scrub for these professional litigators. We have a whole team of people that research, track, and try to build a list so that you can get those weeded out of your list. So even if it shows not on the do not call list, and I've got consent, and I have all these other check marks in place, if that gets flagged in your scrub as a litigator, it's not worth calling it. And even a call back to that first story where you've got the lead and Jernaya is saying, oh, that's a bad, lead certificate. How much does that lead cost? How much is a lawsuit going to cost you? Risk reward. One of them needs to be thrown away. And my recommendation would be that risky lead. Now, on those lines, somebody had asked, when you were talking about a lead seller using the Troutman Amine 15, and they ingest leads to their system and attempt to contact them, they're asking if the consent and compliance now suffices for their terms and conditions. I'm not sure I understand the second part of that question, so if you want to ask that, maybe go into a little bit more detail. But the Troutman and mean, I'll take this in a different perspective. If they follow the guidance on the Troutman and mean 15, my understanding is not only are they good to go with the current consent regulations, but they're also good for the ones that go into effect July or January 27th or whatever it is, 25th.
Yeah. And to be absolutely clear, right, you folks should be buying leads that are compliant with Troutman and mean 15, compliant with the new one-to-one rules right now, right? Because you want leads that are going to be valuable after January. If you're buying leads that are not compliant with one-to-one, then those leads have an expiration date, right? They might as well have an expiration date just stamped right on them, because come January, you cannot call those leads anymore, right? They are gone, like poof, as if they don't exist. Now, you can call if you're not using regulated technology. If you're using like Safe Select or the human selection platforms, you can still call the leads. But if you're going to be dialing at scale, you want to use your AI, you want to use pre-recorded calls, you want to use your automated systems, you've got to start complying with the one-to-one. You got to start doing it right now. And again, the reach buyers, we're definitely saying buying right now. All my clients, I'm telling them, buy one-to-one now. Don't wait until January to start buying one-to-one. You're not going to have a pipeline. It makes no sense.
Yeah, and that's an excellent point, because that's where you really run into the situation of, it shouldn't be a race to beat the clock. How many of these leads can I buy now, because then I can keep calling on them and one-to-one doesn't apply to me. If that's your thinking, you're wrong. You could buy the leads now, but if you don't have that one-to-one consent, like Eric was just saying, good luck in January with those. Those are not leads I would be calling. But looking at that even further, though, is if they're buying these leads and they're following all these processes now, or maybe if we had been doing that 3 years ago, maybe we'd have a lot less of some of the newer regulations that are coming out now, because people were taking care of themselves, or people were policing themselves. And I think this is where adopting an SRO framework would really be beneficial to businesses, where they could start being good actors in the space today. And maybe that will help better differentiate the lead generators and marketers on this call that are acting in good faith versus the ones that are the auto call warranty scam type things. So,
yeah, I mean, there's no question. Like reach is kind of where folks need to be headed here. It is the industry's SRO. We're working with the regulators. I feel very strongly that within about a year, it's like either you're in reach or you're kind of just self-professing yourself as a bad actor, right? We don't have 100% adoption yet in the industry of the good actors, but everyone's like, they know it's time, right? And so I would imagine come January that it's just going to be basically everyone who's good in the industry and complying with the law is a reach member, and the regulators know who's on the naughty list then, because if you're not on the nice list, there it is. And look, I say this gently because I love everybody. I want everybody to succeed. But if folks don't want to comply with the law and they want to take risks and they want to try to race to the bottom, right? That was the problem with the industry for so long. That's what got us here, right? People, and I get it, right? A bunch of geniuses, right, in lead generation. I say that like sincerely, I'm not being mean. I mean, literally, they're geniuses that could be, right, at IBMs and Metas and all the big companies, but they don't want to be because they are contrarians, right? They like to do things their own way. I respect it. Believe me, I respect it, right? But wanting to do things your own way, wanting to be free of regulation isn't an excuse to just go out there and violate the law and do things in your own way that hurt consumers, right? So I know you don't want to conform. I know that. I respect it. In fact, I love it. It's one of the reasons I love helping this industry so much is you've got all these like really awesome, brilliant, non-conformist minds that are out there just throwing stuff off a wall, and I love it. But do it within, if you can, color within these lines. I don't like to stay within the lines, but here, just keep these lines in mind. Join Reach, be part of the solution to create a long-lasting, holistic ecosystem. And believe me, there's so much room for innovation still. Your contributions are going to be very, very welcome out there. Don't feel too hemmed in, but just kind of get off that murky alleyway with the bad guys and come, get into the light, deal with the good guys. I mean, simple as that. That's my pitch for you today.
I think that's one of the things with Joseph Kenny's story with PowerSol that really hit me. This is a guy who's starting a solar company, and he sees an opportunity. I live in Phoenix. There's sunshine 365 days of the year, prime market for solar. So he's like, I see an opportunity. He's going out, he's building his small business, trying to accomplish things. And you see that with small businesses all the time, where they try to do some guerrilla marketing or something out of the box, like you said, with their marketing efforts. A lot of them probably aren't aware of the landmines that they could be stepping on in the TCPA world. So aligning yourselves with the right advocacy groups, the right educational opportunities, things of that nature will help you still find that way to carve out your own unique path, but do it without constantly getting sued or have, an attorney general sending you a nasty letter or something like that. So, make sure that you're doing your research on that. Now, speaking of which, I'm going to cover this one, briefly, but you guys covered a story about the cost of the DNC lists going up. That's another area that people need to be very conscious of is on top of everything else, unless you have the right type of consent and you've gathered it in the right way, you've got to scrub against not only the national do not call list, but there's 12 states, I believe, that have their own independent do not call lists as well. But the costs for the DNC lists are going up. Now that's interesting to me, I think specifically because the way the cost structure for the DNC list works is on a recovery model. It's based on how much does it cost to operate the list, the enforcement actions behind it, some of the various components that go with it. But that's a big part of how that cost is defined. And we talk about some of these creative ways to conduct business. One of the services, the core service of contact center compliance is do not call scrubbing. That's something we started doing from day one. That's how we became DNC.com. We are aware that there are companies out there that are allowing people to scrub the do not calls without paying the proper registration call fees. And when they do that, when you get businesses dropping out and participating in the payment of do not call lists, then that makes all the legal actors' costs go up because that cost is spread across the number of perceived users. We've actually in the last month we've issued a couple cease and desists and some injunctions against a few companies that we have reason to believe are engaging in those practices, allowing their customers to engage in those practices. But what kind of problems could people be looking at if they say they have somebody come after them in a lawsuit? And it turns out that maybe they did engage with one of these where they scrubbed the do not call list, but they didn't have a SAN when they scrubbed that. Will that cause them any issues, or would that potentially get discovered in court?
Well, it might. But let me start by saying I hate the fact that they're raising the cost of scrubbing the DNC. I think it's ridiculous. And when I am your president one day, ladies and gentlemen, and it's just a matter of time, it'll be free. Okay, because we should not have to pay to use the DNC list. And I think every American agrees that marketers should have access to the folks that don't want to be called. And I say this with love, Beth, because I know you're probably listening and you hate when I say this, but the reassigned number database should be free too, right? These should be free tools that are available to callers so that they don't bother people who don't want to receive calls. I'm speaking as the president of REACH, right? An organization designed to prevent unwanted robocalls. These are two really, really easy things, government, that we could do to help the goal of stopping unwanted robocalls. Give people access to tools and don't charge them an arm and a leg for it. My God, why are you charging them more? Makes no sense. But to your point, Isaac, yes, you have to have your own SAN, guys. Go out there, get your SAN. That's what the regulations require. Don't cheat. If you're stealing, it's just like stealing anything else, right? Like follow the commandments. We don't steal things, right? And if you're off, not using a SAN, then you're technically taking a service. Again, in my opinion, it should be free, but until it is free, you can't just go and take it, right? Like that's not the way things work. So do things the right way. There's not a private right of action, unfortunately, perhaps, to enforce that SAN, but the regulators do ask about it. I've seen it repeatedly in CID. Show me your SAN, right? You don't want the regulators coming and asking you that, and you'd be like, "Oh, I don't really have one." That's not where you want to be. Okay, you want to be really thoughtful about that.
Which is interesting because under the TSR, where you don't have the private right of action like you've got in the TCPA, you do have these stiff $50,000 per violation fine. So there's a bit of a trade-off. When you've got the FTC looking at you, it's going to be potentially even worse than some of these class action lawsuits. So I don't know if I can really take a firm position on which one I would dread more. So just stay away from both, and you should be a happier person.
There's wisdom to that.
Before we move on to our next story, got a couple questions here. Going back to the Troutman Amine 15, the clarifying on that question from earlier, it would live on a site as an example, LendingTree, the favorite example of everybody. LendingTree now has consent for the language on their site and consent when sending the lead to a buyer. If this person is Loan Depot and he now receives that lead, does that also assume and protect consent to the privacy, et cetera, for Loan Depot? So it looks like I think there might be a disconnect here between the two. So I'm going to take a stab at this first, and then maybe you could jump in on that. I think there's two different types of consent that are being contemplated here. There's the consent to receive call from regulated technology. Theoretically, there could be a separate consent language for do not call lists. But then you've also got your terms and conditions, your access policies, your usage policies, things like that. So as far as the Troutman Amine 15 goes, I believe that's going to be more in reference to capturing the consent for marketing purposes, not necessarily the privacy policy and things like that. You would still want to have that. In this example, when they go to the Loan Depot website, you would still want them to accept the appropriate policies on that site.
Yeah, you nailed it. All right. So that's the Troutman Amine 15 is designed to give the TCPA consent that's required, right? So that in this example, my great client, Loan Depot, who I love so much, would have the right to make those outbound calls in reliance on what will hopefully be a good and valid lead from their good lead partner, LendingTree, who hopefully will follow the Troutman Amine 15 and the REACH guidelines very strictly and give only really high quality, good leads to people like Loan Depot. The entire purpose of that Troutman Amine 15 is to allow those outbound calls using regulated technology. It would not, as written, also provide acceptance of terms and conditions on Loan Depot's own websites, for instance. That would have to be done separately. Now, you could structure as an owned and operated website, there's SIPA risk, there's other data privacy risks. You do want to build in disclosures on your website. Now, we're talking in this instance, LendingTree, right, to make sure that LendingTree has the requirements for itself to share data, right, which is a totally separate issue, folks, than from outbound attempts, right? Outbound attempts, regulated technology, that's a TCPA. Data sharing is a completely different area of law where you've got to be looking at primarily state level regulation, not federal level regulation. And of course, the good folks at Troutman Amine, Pooja, John Hansen, speaking of John, speaking of LendingTree, that guy was at LendingTree for 10 years. You might know something about this. Happy to help you guys out with those data privacy issues, but that is separate and apart from the Troutman Amine 15.
Yeah, but privacy is very important. There have been a lot of stories you guys have covered lately where we're seeing a trend now where people are filing under TCPA and SIPA at the same time. People are trying to use those privacy laws. So privacy, I think, is becoming a new frontier for some of these lawsuits, especially in the states where there is a private right of action. So I think there's one thing to be said about getting the required consent, but I think there's a separate thing to be said about making sure that if you're unclear as to what consent has been given, giving that same notification, requesting that same type of consent a second time where it's appropriate goes a long way. But this is where it also becomes very important to make sure that you're having the entire flow reviewed by a team that understands all aspects, privacy, TCPA, TSR, all the state and federal laws. If you're in a specific regulated field like Medicare, for example, do they know the CMS regs? Things of that nature, making sure that you're covering all those grounds. And also when you're getting that consent, and this is another thing to be very careful about, you're getting that consent from lendingtree.com. You need to make sure that your legal team has reviewed the language that's being used on that lead form from that third-party site. If you're getting third-party leads, you'll want to make sure that that language meets the standards, because ultimately, if you're the marketer, if you're the seller, you're the one calling, you're going to be responsible to show you've got the consent on hand. You can't say, oh, hold on, let me get that from my lead source, because you're already violating the new record-keeping rules. But then you also want to make sure that it was captured in the legal way, because if your defense is not going to be acceptable. Oh, yeah, well, they said they had consent. Turned out the language wasn't right, but that's not my fault. It kind of is. All right, so another question. Does one-to-one ruling apply to both B2C and B2B?
Yes. So it applies anywhere express written consent is required, and that includes B2B. Anytime you're making a regulated technology call to a cellular phone, It doesn't matter if it's a business purpose, guys. Totally irrelevant if it's a business purpose. If it is a cell phone and you're calling with regulated technology, you must comply with the new one-to-one rule. And on DNC, guys, just because you're calling for a B2B purpose, again, does not mean that you're not calling a residential line. Just because someone lists their cell phone number as their business phone, which I do, doesn't mean it's not also their personal phone, which mine is, right? And remember, if it is used for personal purposes, it is a residential phone for DNC purposes. Regardless of DNC, though, when we're talking about regulated technology, right? That's any auto dialer, ringless voicemail, any form of AI outreach, any pre-recorded calls, any artificial voice calls, those all require, if they're being done for marketing purposes to a cell phone, express written consent, period, full stop. Don't care if it's B2B. So please keep that in mind.
Yeah, I think a lot of people get confused between the TSR and the TCPA and the rules that are in each. And when you talk TCPA, it is about the technology. It is about the targeted type of device. So saying it's a business call doesn't do you anything. Yeah. So despite even the dual purpose thing, you could still run into a lot of trouble there. So yeah, B2B, yeah, absolutely. Now, this is a question I actually hear a lot, and this is how long is consent active once the customer fills out the form, the lead form? So, for instance, if they run a nurture campaign on leads that they've converted, how long can they keep reaching out? I don't think there's an expiration on that for a consent form.
Right. So if it's a valid express written consent, like a full Troutman Amine 15, there is no expiration date technically. Now, under the law, right, if you as the caller have reason to know that the consumer is no longer in the market and would no longer consent, then theoretically it could expire, right? I mean, it's tough to think of an example of that, but if you know a consumer is looking for a 30-year mortgage and then somehow 30-year mortgages become extinct in this country, you can't call them anymore because the purpose for which they gave you consent is now gone, right? But outside of the purpose of the consent evaporating, it does not expire. It does not expire. Now, that's different, of course, than inquiry consent, right, which is only good for 90 days, but that's not your express written consent. And again, inquiry consent is only valid as a DNC exception. Inquiry consent does not give you the ability to use regulated technology, not even for 90 days. People sometimes get confused about that, but please understand. Inquiry, 90 days, but only for DNC purposes.
And something important to keep in mind with that is that if you've got that inquiry and you're just talking about a DNC exemption, that doesn't necessarily mean that applies in all 50 states. So while there is a federal exemption for that, you need to make sure you're following the state laws as well, because that could be a big gotcha, especially if you're in a more litigious state. A couple other things I would add on to that. I remember, and I tell this story often, but I remember when all the TCPA stuff blew up, like around 2015, 2012, whatever that was. I said, oh, people need consent to call cell phones. What's the big deal? And the president of my company at the time, she said, well, Isaac, think about it. What happens when someone gets a new phone number? And that had never occurred to me. So that's a time where your consent could also expire, is if it's no longer their phone. And somebody is going to fill out a lead form, but they're not going to contact you necessarily when they've gotten a new phone number. So that aforementioned reassign scrub, that's something we can help you out with here as well. Make sure you're checking for reassignment at least once a month, because that is a very, very, very common gotcha in some of these cases. Another thing I would just
double down on that. Isaac, let me just double down on that, right? This is called, right, compliance 2024 and beyond, right? When you're going beyond, guys, like obviously one-to-one rule, but that reassigned numbers database is so critical. If you, especially if you're into servicing, and look, I'm going to be going on nationwide tour. I've got 10 appearances here in the next 2 months. And some of these are talking about servicing issues, to credit unions and companies that, collect on student loan debt, people where you might not talk to them for 3, 4, 5 years because they are current on their loan. And then only when they go into default, do you make these outreaches. Guys, if you are not scrubbing the reassigned number database, you are just asking to get crushed, because there is no defense when you call a number that you thought was your customer's number, but that number has changed hands. You are liable, strictly liable, under the TCPA, and these are the biggest, scariest lawsuits out there. You know, the wrong number pre-recorded call lawsuits. My goodness, I hate those lawsuits, man. They are so tough. You got this guy, Mike Greenwald. He's so good at this on the plaintiff side. He's so dangerous. And he brings these cases, and it's like, man, right? You know, all the czar's horses and all the czar's men. Like, even we have the toughest time defending these cases. You do not want to put yourself in that position. So use the reassigned number database moving into 2025 for sure. And do it now. I mean, don't wait till 2025. You guys should be doing this now. Now, again, if you are only calling fresh leads that you just bought, right? Live data leads, live API pushes that just came to you for the last 30 days, I get it. You don't have to use the R&D there. That's not going to help you, right? But if you're calling age data, if you're calling customers that have been in your CRM for more than 90 days, guys, that number could have changed hands. You want to be scrubbing that database.
And these extra scrubs get expensive, and we know this. And that's why, you know, when we get customers to come to us, we work with them on their strategy behind it. We have one customer who's, you know, a name brand pharmacy. Everybody would recognize them, I'm sure, if I mention their name. But they scrub their records for reassign. They've got a gigantic list, and they're looking at the cost of initially and saying, oh, I've got, you know, tens of millions of customers. It's cost me a fortune. Well, do you reach out to them all every month? Well, no. Okay, so then in the month you're going to be targeting somebody. We could check to see where they're at from the last time you contacted them, and we could build that strategy to keep those costs down, but help you stay compliant. And if you want to reach out, I don't know if we put this link in the chat earlier, but you know, my team could put a link in the chat. If you want to talk to someone from our team, we'd be happy to do a courtesy check for you. You know, you send us some leads, and we could tell you what percentage of them are reassigned, just to give you an idea of where you're at. But again, if you're getting consent and relying on consent to get around do not call regulations, to use any sort of ATDS or artificial pre-recorded voice, you definitely want to be doing this. Also, if you're calling into the state of Maine, they did just pass a law there this year where it is a requirement to call into their state, period, to have performed that scrub. So very important information there. We'll take one more question, and then we'll go back to the list. And this is, if a system that dials numbers based on a list provided by the user. This is going to be this is one of your favorite questions, Eric. So they get a list of, they've got a predefined list. It's not auto-generated. Is it considered an auto dialer? And I think this is where we'll probably get into some of the discussion around random or sequential number generation for the randomizers.
Well, there's so much going on. I don't know if I want to dive too deep into this, but look, the bottom line is that hypothetical does not give you enough information, right? You could still be using an auto dialer even if you're calling a list of numbers. You could still be using an auto dialer even if you're calling API pushes that are coming in live, right? Auto dialers do not turn necessarily on the use of a randomizer to create a telephone number. Now, that's at the federal level, right? There are exceptions all over the place, but stay with me, right? In order to determine whether or not you're using an auto dialer, you need to look at your code, the source code of the dialer. Does it have the capacity, that word matters, does it have the capacity to use a randomizer or a number generator to generate any integer in connection with either the storage or dialing of phone numbers? And where that becomes so critical is in the sequencing of numbers, particularly around load balancing. It's very, very incredibly common for dialers to have this capability latently. Sometimes there's even like a shuffle feature, so it's not even latent. It's like right there in your face. But even dialers that don't have a shuffle random dial assignment, they do have the ability to queue and sequence campaigns based upon random number generation in order to break ties, for instance, where your prioritization criteria, right, where those data elements match. The system has to know which one to call next. It can break a tie using a randomizer. So bottom line is, many of these systems are going to qualify as an ATDS, at least in some courts. My view is, if you're going to be making non-consented campaigns, right, you're going to try to, for instance, not comply with the one-to-one rule and just trust that your system is not an auto dialer. Okay, that is one path to compliance, but do not take a risk. Do not say, well, it's probably going to be fine, because if you get hit, that's it. Every single call you made, 100% of those calls is now illegal. That's $500 per. Add them up. And, you know, you guys know there's personal liability here, right? So it's not just like, oh, my business will get shut down. No, your business will get shut down and you'll be in personal bankruptcy. And hopefully you'll be able to get discharged in bankruptcy, because Diana May is trying to chase people into bankruptcy on personal TCPA judgments and say that they're not dischargeable. It's crazy the way, like, it's just The TCPA world is just so nuts. Anyway, don't take a chance on auto dialer, right? If you are going to make non-consented campaigns, use human selection, like Safe Select, one of these systems where I've done a white paper, one of these systems where I've torn down into the system, actually gone through the source code. Don't take a risk, guys. Like, I'm telling you, like, again, I get it. Some courts are coming out and they're saying, hey, look, as long as you're not randomly calling phone numbers, that's fine, right? Onesie, twosie district courts, guys, even some of the Ninth Circuit has held the same way. That is not what the U.S. Supreme Court said. I'm telling you, it is not what the U.S. Supreme Court said. My view is you comply with the U.S. Supreme Court's ruling. I don't care what the Ninth Circuit Court of Appeals says, okay? So keep this stuff in mind.
And I would love to have a much deeper conversation over this, but I would suggest you guys come to LeadsCon Connect in Chicago in a few weeks. I will be speaking there. Ari, several from your firm are going to be speaking there. I think you, Pooja, John.
Yeah, Pooja and I are going to be tearing apart the one-to-one rule, giving you guys the absolute latest. Those of you in the lead generation space, you have to be in Chicago for this event. That is going to be the latest and greatest V2.0, the reach standards. Everything's going to be all put together for you. We're going to lay it all out. And secondarily, of course, we will also be touching again on the ATDS component. I think the deepest dive we do on ATDS, though, usually takes place at your summit in Florida in December. So those of you that are really into ATDS issues, that you're going to want to attend that one for sure. But I mean, while we're talking about speaking slots, I mean, my goodness, I'm speaking in Anaheim next week, right? I'm going to be in Austin, those of you in the insurance vertical, at the mega all-state brokers. Then I'm going to be in Chicago with you for the LeadsCon Connect. Then I'm going to be in Salt Lake City. Those of you doing ACA and Medicare, going to be speaking at that big event. And that's just in September. Then we get into October, and I'm going to be in Florida speaking to a bunch of credit unions. We're going to be in Vegas at ITG. There's just a ton of places to connect with us. It's actually easier to find us on the road these days than it is to find us in the office. It's kind of sad. It's kind of true. So, but do get out there, guys. Take advantage of these opportunities.
And I can tell you guys from firsthand experience, Eric and his team do work the room the entire time. So if you want 5 minutes of his time, want to talk, you'll have that access. So, all right, I'd like to talk about, since we're talking about some of these crazy fines, this was just more of an interesting story I saw where I think you had titled it something along the lines of, can you sue the dead? For a TCPA violation, or does TCPA survive death? And in your story, it seems like it does.
What's fascinating is that the TCPA survives death both ways. And so one of the things that's like just one of the darkest stories, there's like a few really dark stories out there in the TCPA. To me, one of the darkest stories was the FTC went after a guy personally, right? And this is, again, personal liability, right? His business was doing X, allegedly, right? FTC sued the business and sued him personally. He died. And the FTC then sued his daughter as the administrator of the estate. I mean, like, holy smokes, dude. Like, you can't even get out of this when you die. It's just nuts. So that's one angle of TCPA surviving death. And then the other angle, which is what you're looking at, is what happens when the plaintiff dies, right? And we've seen multiple instances of this. 10 years ago, God, I've been doing this, guys, for 15 years now. 10 years ago, the law was if a plaintiff died, the claim would die with them, right? Because it was viewed as largely, the TCPA is largely like a quasi-criminal statute. It's like highly punitive, and highly punitive actions die with the person that's bringing the claim. But more recently, courts have, I think, falsely found that the TCPA is remedial in nature and not punitive, meaning that these $500 per call minimums are just designed to, put you back in the same position that you've been if you hadn't received that one phone call, which is ridiculous. We know that these are punitive. These are fines that are being asserted to people for violating the law. They're not trying to make people whole for, missing 5 seconds or 1/2 second of their life. I mean, my hourly rate, even in 2025, should probably be like $4,000 an hour, guys. Seriously, that's what I'm saying. You guys in 2024, you don't want to pay 2025 rates. Even at $4,000 an hour, guys, it's not $500 a second. Yet that's what the TCPA penalties are. So to my eye, plainly, these are punitive fines. Therefore, they should die and expire with the plaintiff. But the courts have been finding the opposite. They're finding that this is merely remedial. And the result from a legal perspective is that even if a plaintiff dies, they can still sue you through the next of kin, through their wife, as was the case more recently in this lawsuit, this article that we did. So I don't know what to tell you. It's just like the TCPA survives death. I mean, it's just like, it just keeps going no matter what, man. I don't know. It's not close enough to Halloween to make us, life after death kind of remark. But it just is remarkable how potent the TCPA is.
Well, and especially when you start thinking about, when people, and I know it's a very morbid topic. I was talking to my daughter about this the other day. It's like, we're talking about retirement because she's at that age where she's getting ready to enter the workforce in a couple more years. And it's, hey, when you start thinking about retirement, you think about, okay, how much money do I need to last me from whenever I stop working until the day I die? And then with your life insurance, it's how much do I need to take care of anything I've left behind? Well, if you're leaving these massive settlements behind you, that life insurance could even run out quickly. There was another story you covered, and I just want to talk on this really quickly, especially since you mentioned the $4,000 an hour. This was $31,000 for a settlement for 5 calls and 1 text message. So let's just call it an even 6 calls. We're talking over 5,000 per. So just 1 hour of time versus these 6 fines. Now, granted, in this case, you had one of those weird situations you've been reporting a lot more on lately, it seems, where the defendant doesn't even seem to show up for court. But a serial litigant, $31,000. I mean, I don't know what more there is to say on that one.
Well, there is something to say. It's actually really important. This guy, Anton Ewing, has a really interesting angle that he's bringing now. He's the first one to bring it, but it's fascinating. Everyone needs to pay attention, which is if you are recording your pre-recorded calls, right, your Press One campaigns or your AI outreach, I think most people are recording those, guys, right? You have to have consent from the call recipient before you can record. And how can you do that if you've got a pre-recorded voice that's being played, right? So this goes all the way back to the Troutman and Me 15. It doesn't capture terms and conditions. I think the Troutman and Me 15 is going to have to be modified to like Troutman and Me 16, not from a TCPA perspective, but from a CIPA perspective. Because in California, under the California Invasion of Privacy Act, you have to have the consent of the caller before you can record them. But the called party, excuse me, not the call. You have to have the consent of the called party before you can record them. So if you're recording your outreaches, and that's what happened with Ewing. He claimed that these defendants, not only did they make an illegal pre-recorded call to him, but they also recorded the pre-recorded call that they were making to him. As a result, he got $1,500 for the call. Actually, he sought $1,500. The court only gave him $500 for the call as being a pre-recorded call, $500 for the call for being on the DNC list violation. So it's a double violation under the TCPA, but only $500 each. It could have been $1,500 each, but the court said only $500 each. But on top of that, $5,000 per call because they were recorded without consent. And this is interesting, guys. This is groundbreaking stuff and something that everyone needs to now be aware of. If Ewing can think this up, the plaintiff's lawyers around here can think this up, and this is going to be a new battlefield. So definitely, if you're using pre-recorded calls, which already puts you at big risk, guys, you know that. AI puts you at risk. Make sure that you are not recording those calls without consent. Very important.
I'm going to go through 3 questions really quickly here because there's one more story I do want to touch on quickly. Recording, yes, the recording of this will be on our website probably in about 2 days. So dnc.com, look for the webinar section, and you should be able to find this. Next question is, does the analysis change regarding the source code issue if the business only calls customers based on an EBR inquiry and using a click-to-dial system? So that's actually an interesting one because the inquiry and EBR part doesn't quite matter as much because, again, we're talking regulated technology versus do not call. And EBR and inquiry is going to be, by and large, related to just do not call exemption. That's not really going to do much for a click-to-dial.
No, I mean, this is the core of it, right? You're calling with EBR inquiry, so you're not going to worry about DNC issues. But the question remains, are you using an auto dialer, yes or no? And the fact that you're clicking to dial does not matter. After footnote 6 of the U.S. Supreme Court case in Facebook, click to dial is irrelevant. People that are using click to dial thinking that saves them, wrong. Now, selecting a human being going into a CRM, pulling up a record and clicking on it, yeah, sure, that is a manual attempt. That is legal. But like clicking like a chicken through a streaming list of numbers that's static and determined by the system and all they're doing is this, no, guys, that ain't going to work, right? Even if you're using a workflow tool that's presenting the next in order and you're just clicking the next in order and the agent has no discretion in terms of who to call next, that in some courts is going to be an auto dial. So you have to be really, really thoughtful. This person that asked that question should give me a call. I'll give you like 20 minutes for free. Like you just cannot risk your entire company and your personal livelihood, assuming that your click-to-dial system is not an auto dial. Guys, I'm telling you, that's going to get you guys just crushed. Okay, you've got to be more thoughtful.
Last question I'll cover is if a group of affiliated companies can obtain one-to-one consent together in one form, or does each separate but affiliated, same common owner need a separate consent? I think by and large, you could put them onto one form, but you're going to need to get consent on each individually. Do you want to elaborate more than that?
Yeah, no, this is the darkest part of the new one-to-one rule, guys, is it's going to crush first-party lead as well. And I use the Wells Fargo example all the time, right? Right now, today, you go onto a Wells Fargo Bank NA form, and you will accept consent for Wells Fargo Bank NA, its subsidiaries, and its affiliates, and that's fine. But after one-to-one becomes the rule, you cannot do that anymore. Entity-specific consent is required. So if Wells Fargo Bank NA is going to call you, it has to say Wells Fargo Bank NA. If Wells Fargo Financial LLC is going to call you, it has to say Wells Fargo Financial LLC. If it says, if Wells Fargo Home Mortgage LLC is going to call you, Wells Fargo Home Mortgage LLC has to be on the form. And the consumer has to select that specific entity, which means in the first party setting, those of you that have kind of fractured enterprises where different services are being provided by different entities, you're going to have to determine which entity is going to provide the good or service to that consumer based upon the call to action and the information the consumer has provided, and dynamically fill that form. And that's just in the first party setting. Same rules apply in the third party setting. And it's even more complicated, of course, because now you have to know which of your partners' entities are going to provide that good or service. Good luck, my friends. I love all of you. I hope that you succeed.
Yeah, I think this is probably the most complicated part of one-to-one is the affiliate question. We could spend an hour on that. I heavily recommend that is the number one thing you talk to your legal team about. If you don't have someone who's an expert, reach out to the folks at Troutman. He's talked about this numerous times. This is a lot more complicated than you would think. I wanted to talk about AI, but we're out of time here. So we're going to drop a link in the chat about this. But, Eric has mentioned AI probably a dozen times on here. AI is the new frontier in technology. Everybody, or almost everybody, I think Eric and I are a little bit more skeptical of AI than some of the rest, but everybody jumped on the AI bandwagon. AI agents are all the rage. But that is the next big front of regulation. And Troutman broke a big story about that. But more importantly, the reason I want to bring it up is Eric's mentioned Reach a few times. Reach is going to be drafting comments, drafting an opinion. We're not going to take it, at least from what I understand so far, and we haven't finished what's being made, but we're not going to say, oh no, AI has to be able to do anything it wants to do, leave it alone. The whole point of Reach is creating a calling and marketing space that respects consumers, avoids harassment of the consumers, but at the same time allows businesses to function. So Reach will be getting involved. Reach wants opinions from the industry. So if you're not a Reach member, please get involved. Be a voice in what's drafted, because we're not doing this on behalf of TCPA World or on behalf of Troutman or Contact Center Compliance. It's the industry that Reach is trying to represent. So if you want to be a voice in the industry, become a part of the industry's voice. And with that, we're already 2 minutes over, and I know you've got a very busy schedule. Eric, anything you want to add before we call it?
No, love you guys. Do join Reach, and we'll see you folks in Chicago, if not sooner.
All right. Thank you, everybody. Take care. Bye-bye.